It's about the restoration of our republic. We want to educate, encourage, enable the power. We stand for integrity, honesty, self-reliance, self-defense, and most importantly, no compromise on our foundational principles. This is America's Voice Now.
Find America's Voice Now on Facebook and at americasvoicenow.org. Here's Michael Evans.
Good morning, America. Today we're going to have a couple of discussions, not the least of which is regarding the Missouri override session on the Second Amendment Preservation Act. There's a lot happening this morning, and we're going to cover four different topics. The first one we're going to cover is going to be the issue of the Missouri Second Amendment Preservation Act veto override, which is going to occur today. There's a rally being held at the Jefferson City Capitol, where they're going to drive an impact to the state legislators and the assembly to make sure that that override is properly done. We're going to talk a little bit about that, and we're going to talk about why the governor has made serious mistakes and doesn't understand not only our Constitution, but also our state. And so we'll talk about that first. Our second issue is I want to talk a little bit about remembering Benghazi. You know, today is 9/11, and as a result, it's important, I think, that we understand and remember not just 9/11 in New York, because that attack was a terrifying and terrible attack on our nation, but it was not one that was perpetrated by our own people. I guess that's the simplest way to say it. Benghazi, on the other hand, was completely our own fault and responsibility. We failed to act again, and the resulting deaths that occurred there, while they were only 4 and compared to 3,000, were even perhaps more tragic than the 9/11 for a number of reasons, not the least of which is that we were actually working in an unauthorized fashion to pull off an arms deal there. And so the motivating factor behind 9/11 Benghazi is different than 9/11 New York. And we're going to explore that a little bit. Our third segment is warrantless wiretaps, the NSA, and you. Now, I know that, and I've gotten emails about this, you talk too much about the NSA and the warrantless wiretapping issue and the surveillance and the spying. Well, with all due respect, I would disagree with that. I get more email that tell me that we're not addressing it enough. But most importantly, I think it's important that we educate ourselves about the true nature and impact of what this means to you on a day in and day out basis and the long-term ramifications of that. And then our fourth and final segment is going to be the speech on Syria and in reference to what the president did yesterday. In fact, I posted an article up on Facebook in reference to it because I'm a little disturbed by what I heard last night, and I think you should be and are too. And so we're going to talk a little bit about that, and we're going to understand what I think was the real true motivation behind this president. Okay, let's get on to our first topic, which is the Missouri Second Amendment Preservation Act. There's going to be a rally this morning that's going to be held, and the gun owners and advocates for the right to keep and bear arms have, for all intents and purposes, been summoned to appear on the steps of the State House in Jefferson City at the Capitol. This is a veto override rally that is aimed at driving support for Missouri legislators to override the governor's veto of the Second Amendment Preservation Act. Now, what's important to understand is that Nixon vetoed this effort back in July 5th. And I posted an article at that time up on americasvoicenow.org and on Facebook, of course. And basically, I outlined why Governor Nixon doesn't understand our Constitution. And I think what's important is that we understand the ramifications of what he did and the motivation behind why he did it. And his failing to understand the nature of state assemblies, the intervention and interposition and nullification processes, and the rights and duties and obligations that are associated with being a state legislator and a state governor as opposed to being in the federal side. He vetoed an important interposition bill that was passed overwhelmingly by the Missouri legislature with significant and overwhelming support on the part of the constituency. So what that tells us is that the governor is operating against the best wishes and the known best wishes of the constituency itself. House Bill 436, which was entitled the Second Amendment Preservation Act, was passed in response to the extra-constitutional overreach of the federal government, where it relates to firearms, magazines, and accessories in the immediate aftermath of the Newtown school massacre in Massachusetts. The bill was based on the constitutional rights of states to declare those federal laws that are unconstitutional as null and void and of no effect, quote unquote, because they are violative of the Constitution itself. And this was stated by Madison and Jefferson in their famous disagreement with the Alien and Sedition Acts, which were ultimately repealed in large part due to the efforts of these two particular founders. The Sedition Act, in particular, was a clear and distinct violation of the First Amendment rights against free speech. And many, many citizens were imprisoned simply for speaking ill of the president, and similarly situated political parties in Congress and the House and Senate and so forth and so on. The Sedition Act literally imprisoned hundreds upon hundreds of Americans for their free speech, for exercising their free speech rights, I should say. And so Jefferson and Madison came out and wrote a number of pieces that were clear disagreements with this and explaining the concept of interposition and, quote, nullification. Now, the real issue here is that the governor doesn't understand that nullification is a principle that overrides the supremacy clause arguments that are out there. In his letter where he vetoed the bill, he outlined two specific reasons that he rejected the bill. Both were horribly inaccurate. For a man who at one time was the Missouri Attorney General, one would surmise that he might be more familiar with constitutional law than he actually is. Alas, on the heels of another alleged constitutional professor, the one sitting in the White House, it seems that the revisionist progressivism that we experience today is just exemplified as the height of hubris when it comes to the ultimate law of the land. His first argument was based on a very, very significantly flawed premise. One, that the federal government can use the so-called supremacy clause to enforce unconstitutional law and mandates on the individual states. And two, that the courts, including the Supreme Court, are the supreme and final arbiters of the Constitution. Neither of those positions could be further from the truth. His second, and I'm going to get into in detail why in a moment. His second argument deals with the violations of the First Amendment and free speech. Since the governor himself is actually guilty of violating the privacy and the lawfully protected information of 165,000 innocent Missouri concealed carry holders, I find this to be not only ironic, but hypocritical. We can only surmise that his true intent on this argument was he was attempting to forestall passage of legislation that he would actually be found guilty of himself. Because in this thinly veiled argument, which was clearly self-serving, the real issue here is that he was attempting to present the position that by allowing the release and dissemination of this information, he was actually just adhering and adhering to federal requests for information. So let's understand something. In the first argument, he quotes the U.S. Constitution's Article 6, Clause 2. And that clause states the following, quote, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, and anything in this Constitution or laws of any state to the contrary notwithstanding." Okay. Unfortunately, Nixon failed to read the clause in its correct context, because the language phrase says, quote, "which shall be made in pursuance thereof." And that statement directly reflects the passage of laws by the federal government, but they must be made in pursuance thereof of the actual Constitution and the laws of the United States. It says, "This Constitution and the laws of the United States, which shall come after, shall be made in pursuance thereof, and all treaties made which shall, etc., 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 become the law of the land." It requires that laws must be made in pursuance of the Constitution, not in direct violation thereof. And when you look at the language of the Second Amendment itself, that language is very, very clear and extraordinarily definitive. Quote, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms," here it comes, "shall not be infringed." Now, according to Black's Law Dictionary, which is the definitive standard for law, shall always means must. It is an imperative statement. It is an order. Infringed is defined as a trespass or an encroachment. And that is always considered a violation, especially when it is used to describe an invasion of rights. Therefore, the phrase "shall not be infringed" means that no law can be made that would encroach, limit, or trespass upon the rights of people to keep and bear arms. It's that simple, folks. Any true construction review of this statement and the governor's statement clearly defines the reality of this issue. And that is, all law limiting the Second Amendment, whether passed by the state or passed by the national government, is null and void and of no effect. Some people would argue with me on this point that various laws may be passed to limit access to firearms for criminals, mental health risks that are posed by, those who aren't completely in control of their faculties, and other types of limitations that they want to impose, including, by the way, those who have been involved in domestic disputes and that kind of thing. What's important to note about all of this is that once a compromise is allowed, especially when we talk about in the manner of what would be considered or construed as a definition, it's always expanded to annex more and more and more risks underneath the umbrella. Now, we've seen this time and time and time again. When we look at the issues with the NSA and the monitoring and the spying as an example, there's a perfect example for you. What started out to be, we're only going to monitor international traffic to verify that the terrorists aren't out there, plotting, now has become turned around on, the funnel has been inverted, and now we're actually gathering and capturing everything from everyone, about everyone, building dossiers on every American. It's called mission creep in parlance. So what this tells us is that whenever government has an opportunity to massage or verbicide the definitions, it's always expanded to annex more and more of your rights away from you. Ultimately, it covers every, quote, undesirable thing based on the subjective judgment of whomever is making those rules. And that, ladies and gentlemen, completely eliminates and obviates the rule of law. That goes from the rule of law and now turns us into the rule of men. And that is completely opposite the pretext, the concept, the intent, and the construction of our Constitution. It should be noted that, quote, from Thomas Jefferson, "In questions of power, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. Now that was given to us as a warning and a declaration, because the reality is that we know that when we trust in the goodness of man, the ethics of man, the confidence in men to do the right thing, we are routinely exposing ourselves to disappointment and failure. The opposing argument, when it's put forth by those who want to twist the Constitution using these principles of verbicide and redefinition, is usually couched like this. Our founders couldn't possibly have known about machine guns. Or, does that mean someone can own a Sherman tank or an F-16 airplane? You see, the absurdity of those arguments is always easily exposed. And so when you hear those and you're talking to people and you're trying to have a rational discussion, but they drag into it the theater of the absurd, you need to understand the skill set that's necessary to respond to those questions. And you also need to understand that those questions are always intended to do one thing. That is redirect the conversation away from logic, reason, and direct the conversation into the emotional realm. Once it steps into the emotional realm, you can no longer bring it back into the realm of reason and logic. In other words, once you've stepped over the threshold into emotion, the conversation ends right there, because you can no longer have an intelligent, articulate discussion with someone who is willing to use the concept of reason and logic. Now, I'm not suggesting that you can never utilize emotion in a conversation. What I am saying is that when you talk about issues where we're talking about hard and fast rules of the Constitution, emotion does not play a part and should not. Emotion plays a part in many things in our world and in our lives, but not in these areas. And the reason for that is clear. Once you allow emotion to break down the barriers that the Constitution has drawn, there's no way to go back and replace them. All right. So let's continue on here and understand what we're dealing with. When these people throw these types of arguments out there, what we need to understand is that the issue of infringement always results in your loss and derogation of your individual rights. Any law that limits the Second Amendment, irrespective of anything else, is unconstitutional. Because, and I can prove this, by the way, are you aware that the rules of Marque, and if you're not familiar with this, look it up. It's Marque. The rules of Marque were originally designed so that the federal government could hire private ship owners to utilize armed vessels to help defend the nation. And the reason for that is because they knew that they had limited functionality, they had no standing army, they had limited resources, they didn't have the ability to mobilize large volumes and groups of people and move them, like we do today. You can't just throw them on an airplane back in the 1700s, right? Or even the 1800s. So what they needed was the ability to quickly mobilize men and materiel and weaponry to a hotspot, if you will, when one arose. And so Jefferson actually intoned and requested that private ship owners utilize their facilities and their equipment to help defend and protect the nation against the Barbary pirates, as a perfect example. Now, how could he have done that if the ownership of weaponry equivalent to what the military was in possession of at the time was unlawful? He couldn't possibly have done so. And so what we really need to understand is that anytime that we start applying these limits, if you will, and we annex more and more risk underneath the umbrella, what we end up with is a subjective review of what those rules and limitations are. And that's why the Constitution is always a hard and fast and not an emotional document. Now, one would, certain people would argue that free speech is not a right, right? One would not say that free speech is a right, except for those who have spoken negatively before or lied under oath, or that someone who is mentally unbalanced can be silenced by force, would you? In other words, we wouldn't put the argument forth that because someone has spoken negatively once prior or lied under oath, that person is never allowed to speak again. The argument that the government can limit by infringement the rights of people to own and possess weapons is anathema to the principle of the rule of law in a nation of liberty. No law that limits firearms ownership or possession or actual use can be tolerated, because if we do so, we invalidate the entire structure of the Constitution. And that means that all other binding clauses are effectively rendered null and void themselves. In other words, if we break through wall 1, then the rest of the walls have no solidity, no value, and no constructional consequence. Any law that infringes on firearms cannot be made in pursuance of the Constitution simply because the Constitution itself strictly forbids that particular action. And it also should be noted that, the claim that we should trust government to do the right thing for us is always debunked by the statement of Jefferson that says let's not fall under the guise and allow the veil to be pulled over our eyes with this claim of confidence in men. Instead, we have a Constitution that is intended to do one thing, specifically bind them down, so that we do not have to live under subjective arguments. Now, when we talk about those people who want to throw the argument out that, they couldn't possibly have known about machine guns back then. They didn't have them in 1776. Let me ask you a couple of quick questions. If I ask you those same questions about the First Amendment, they would go like this. Did the founders envision television, the internet, the iPhone, or 24/7 hour propaganda programs like MSLSD, Communist News Network, faux news? Of course not. Yet those people who benefit from those mediums would be the first to holler if you were to attempt to limit their free speech based on the type of equipment that they use to deliver their message. Am I not correct? In other words, if you tried to silence them in their chosen media, then they would immediately start squealing bloody murder. What you really need to recognize is that the rule of law does not depend upon the medium or the weapon itself. The rule of law is the concept. We're going to take a break. When we come back, I'm going to finish this because I think it's important. I know I was going to talk about this warrantless wiretap thing, and Benghazi and so forth, but I think it's important we understand this, especially in light of today's veto attempt to override this veto. If our Congress or our state assembly does not override this governor's veto today, we should make it our business to make sure that every member who does not vote to support it and vote identically in the way he voted back in when the original vote was held is immediately removed from office.